Welcome to Navkar Digital Institute, India's first virtual learning platform for professional coaching. In today's video, we'll be covering the subject of indirect tax laws, and that too particularly custom subject, where we'll talk about the chapter of Settlement Commission. When I say Settlement Commission, it is mainly a judicial body which has been set up by the central government, and it talks about all the settlements of the disputes or cases which are pending with various bodies. Now, mainly all the provisions related to Settlement Commission are covered under section 127A to section 127N. Now, basically, if you refer to Settlement Commission, it is nothing but an alternative channel. Now, when I say alternative channel means what? So, I mean, like what generally happens is, whenever there is something wrong which is done by any assessee, I mean, that is what at least department believes, then they will serve a notice demanding duty, and that is what we consider as in demand proceedings or adjudication proceedings. Against that, if assessee is, I mean, like if the proceeding is against assessee and assessee being an aggrieved person, he goes for appeal. If required, he may even go for revision, and it may also result into prosecution at a later stage. So there are many proceedings. A complete alternative to all these proceedings is what we considered as a settlement commission. In that, the assessee, the person who has done something wrong, is required to give a true and full disclosure of all his liabilities. He has to accept his liability and he has to pay the taxes, and against that the judicial body, the court, will help them to settle all his liabilities, and that is why we consider that as an altogether an alternative channel, because normal channel is always there. So he may fight with the adjudicating authority, then he may go for appeal, then he may go for revision, whatever is required. But the other option is, rather than fighting in all this with all these bodies, you straight away accept your liability and approach to Settlement Commission and get your matter settled. So that is why we say it is nothing but an alternative channel for the settlement of any disputed case. Now, basically, when we talk about Settlement Commission, as we have already discussed, it is an alternative channel, so it helps in speedy recovery or speedy settlement of the cases, which is nothing but a great benefit to the departmental authority. I mean, just try and understand, if I say I've paid a tax of, let's say, 10 lakh rupees in a particular transaction, and a department officer serves notice to me saying that you are not liable for 10 lakh, rather according to us you are liable to pay 50 lakh rupees of tax. So show us some cause that why we should not charge 50 lakh rupees and all that. This is what we considered as an adjudication notice. Basically, it's called show cause notice. They will say that show us some cause that why we should not levy this 50 lakh rupees tax on you. Now, this is where we say that an adjudication proceeding has been initiated. Now, technically, when adjudication proceeding gets initiated, obviously I am going to fight against that. So when I'll fight against that proceeding, so I'll provide evidences from my side, department will consider their points, and ultimately an authority will pass an order. Now, either that order can be against me or that order can be in my favor. Let us say the order is against me. So when the order is against me, there can be two possibilities. Either I may accept it or I may again fight against that, so I'll go for an appeal. So if an adjudicating authority, that is a department officer, a proper officer, has passed an order, then I'll go in appeal and I'll approach commissioner appeal, which is considered as first appellate authority. It may so happen that in entire proceeding, even the commissioner appeal passes an order against me, then I can approach tribunal. When I'll approach tribunal, again the same thing as where a tribunal will pass an order, and tribunal may again pass an order in favor or against me. Let's say tribunal again passed an order against me. So then the option is I can go for High Court. If required, I can go to Supreme Court. And till the level I'll keep on fighting, obviously there will be a delay in payment, because I'm not going to pay the taxes if I'm continuously fighting. So if there is a delay, so that may, I agree that even if there is a delay, they are going to charge an interest. But technically, it is nothing but a delay in settlement, it is delay in recovery of the outstanding dues. So it's a long process. As against that, if assessee at an early stage itself accept all his liability and request for settlement, then it becomes very easy recovery for the department. So that is why we say it's a speedy settlement of all the cases, because assessee is accepting his liability. So it becomes a great benefit to the department, that rather than fighting till the highest level and incurring even expenditures, because also they are supposed to hire lawyers and incur a lot of expenditures on this kind of proceedings. So if assessee himself accepts his liability and pay all the outstanding dues, then obviously it's a speedy recovery of all the cases. So that is why it is a great benefit to the department. As compared to that, when I think from the perspective of the assessee, this is again an equally beneficial situation for him. Why? Because one of the most important power or point in relation to settlement commission is, settlement commission can waive off your penalty and prosecution. An extraordinary power which is available to the settlement commission. They can simply waive off your penalty and prosecution. And when I say they can simply waive off your penalty and prosecution, it becomes a great blessing for any assessee. Reason is very clear, because if he has done something fraud, anyways he is supposed to pay the tax on that. He may even supposed to pay that tax with an interest. But by paying tax and interest and requesting for settlement, if he gets an opportunity to come out of penalty and prosecution, I think it's a blessing for him. So on one side, it is a big benefit for the department because it results into speedy recovery. On the other side, it becomes a big benefit for assessee because it's an opportunity for him to come out of the penalty and prosecution, to get an immunity from prosecution. Then accordingly, it is considered as a kind of a win-win situation for both the parties. So that is why I think this is considered as one of the best sorted proceedings which can help assessee as well as which can help department. So that is one of the point that we were talking about, is speedy settlement of cases. Now with regard to the setup that has been done, the settlement commission is having its head office located at New Delhi. Over and above that, it has 3 offices. One is there in Mumbai, another is there in Chennai, and another is there in Kolkata. So basically it operates at 4 locations. An aggrieved person will always address chairperson of the settlement commission, who is situated at New Delhi. Then depending on the issues involved, depending on the legal aspects involved, financial aspects involved, a bench means a special court that will be formed. That bench can be formed at maybe New Delhi, that is the HO of the settlement commission, or maybe at any of this office which is located at different geographies. But prima facie, we always need to understand that whenever you apply to settlement commission, your application should always address to the HO at New Delhi. Now this is basically an introduction of what is a settlement commission. Now let us technically talk about the procedural aspects of the settlement commission, that how it actually works. When can you apply to settlement commission, and all those points that are relevant over here. So when I say settlement commission as a procedural aspect, when we think of application, so we always need to keep few things in mind, that who can apply to settlement commission. Number one aspect, okay, any importer or exporter. So as an importer, if I have imported certain goods on which I have probably evaded tax liability, then obviously as an importer I can apply to settlement commission. Or maybe as an exporter, when I exported certain thing and I evaded certain liabilities, or I evaded taxes, so obviously I can apply to settlement commission. So obviously an importer or exporter can apply to settlement commission. But more important, any other person also. Now this is something which is unique. It says obviously an importer and exporter can apply to settlement commission, which is logical because they have done a tax evasion, and obviously they are liable to pay that tax, interest, obviously penalty, and if it's a big thing, then probably again it's in prosecution, subject to offenses and all that. But when I say any other person, it has been very clearly drafted as any other person can apply for a show cause notice issued to him. Now why a concern would be there that a show cause notice should be served to any other person? So now let us talk about this. Probably one of the best example over here, any other person, maybe would be a clearing and forwarding agents, or a CHA, or a custom broker, whatever you name, because the name keeps on changing. I think in earlier days we were calling it as clearing and forwarding agent. Then I think it has been renamed as CHA, which is custom house agent, and I think the revised name today is custom broker. Now basically what is the point over here? Let's say a person is doing an illegal import or export. So obviously whenever he is doing an illegal import or export, he is doing a violation, and I, being his clearing and forwarding agent, I am helping him. So technically when the things will be caught up, So he'll be caught up, because of doing wrong thing, and I'll also be caught up because I'm helping him in doing wrong things. So obviously he'll be caught up, I'll be caught up, both of us will be caught up. So when I say both of us will be caught up, so obviously it is going to result into a big issue. Now technically, it may so happen that whether he is applying to settlement commission or not, that becomes his aspect, but I can sure shot apply to settlement commission to come out of my liabilities. It may so happen that his application with settlement commission has been already considered and the settlement commission has passed an order, and in that proceeding somewhere he has taken my name, so now the notice is getting served to me, so I can obviously against that show cause notice approach settlement commission. There is no doubt about that. It may so happen that against that person a show cause notice was served and his proceedings are already pending with any of the adjudicating authority, or his proceedings are already pending with settlement commission, and based on that a notice has been served to me, and obviously I can apply to settlement commission. So I may not be an importer, I may not be an exporter, but I am any other person, and any other person to whom a show cause notice has been served. So obviously when a notice will be served to me, so I can say that my case is pending with the departmental authority, and whenever your case is pending with the departmental authority, to be very precise, adjudicating authority, whenever your case is with an adjudicating authority, then obviously you can approach settlement commission. So obviously who can approach? So any person can approach, maybe an importer, maybe an exporter, or even any other person. Any other person can also apply to settlement commission when a case is pending. So a notice has been served to him. See, basically it's a clear thing. You can't approach to settlement commission on your own. You can approach only when a case is pending against you. So basically a notice has been served on you and yet the order has not been passed. So in that case you can always approach settlement commission. So importer to whom the notice has been served, obviously he can approach. An exporter to whom the notice has been served, obviously he can approach. Any other person to whom a notice has been served, he can also approach. Without notice, you can't go suo moto to settlement commission saying that, okay, I have done so and so activity in so and so year, in so and so day, by doing so and so, please help me to settle something. But you are asking for settlement of what? When nothing is pending, you are asking for what settlement? Keep this in mind that you can ask for settlement of only those things which are pending. Anything which is not pending, there is no question of asking for any sort of settlement. Now, as I have said, when a case is pending, so case is with an adjudicating authority, it has been very clearly fundamental point. You can apply to settlement commission when your case is with an adjudicating authority. Adjudicating authority meaning departmental officer who serves a notice to you. So when your case is pending with adjudicating authority, you can straight away apply to settlement commission. Now, very, very important point over here is, when I say cases with an adjudicating authority, I can apply to settlement commission. So first what I need to identify is, when I say cases with adjudicating authority, so concerned matter is, obviously an adjudicating authority being a department officer has served a notice to me. So an authority has served a notice to me, and now because an authority has served a notice to me, I can say that my case is pending. Now it may so happen that at that point of time when an authority serves notice to me, obviously I have an option. I can either decide to fight. Let's say मैंने एक transaction किया था जिसमें मैंने 10 लाख रुपए का tax भरा था, and a department authority is of the opinion that the correct amount is not 10 lakh, the correct amount is something high, maybe let's say 50 lakh. So obviously he's gonna serve a notice to me. The moment he serves a notice to me, I can say my case is with adjudicating authority. And the moment my case is with adjudicating authority, I have two options. Option number one, either I want to fight against that because I'm very clear that no, my tax liability is only 10 lakh and I'll fight till the end. The other option is, no, I'm aware that my liability was actually 50 lakh, I've just taken a chance. Now, when I say that I'm very clearly of the opinion that my liability is 10 lakh, obviously I'll fight with this. There is no doubt about that and I'll fight till the end. But if I am of the opinion that no, my correct amount is not 10 lakh, my correct amount is actually 50 lakh and I have paid only 10 lakh, now then obviously it's on me that whether I want to take a chance and keep on fighting or I want to accept it. Let us say I am accepting my liability. But then again I have two options. The authority who has served a notice to me, I can straight away accept my liability with him. I can straight away say, okay, I accept my liability, you tell me what is to be done. If I am doing that, then obviously he will ask me to pay 40 lakh rupees, which is differential amount of tax. He may even ask me to pay interest on that. He'll obviously gonna penalize me, and if at all whatever contravention I have done is considered as an offense under the offense and prosecution chapter, then obviously he is going to initiate prosecution against me. So what will happen is, even if I am accepting my liability, I have to pay tax, which I was ready to pay. I have to pay interest, which again I have to pay. I have to pay penalty, and I will also be prosecuted. As compared to that, rather than accepting my liability against the authority who has served a notice to me, I have an option whereby I can straight away approach Settlement Commission. When I approach Settlement Commission, obviously I am supposed to pay tax. There is nobody who can discount you in tax. There is nobody who can even discount you on interest. You are bound to pay tax, you are bound to pay interest, but what I'll get is a waiver from penalty and prosecution. So I'll get a waiver. I mean, I'm supposed to pay the tax. वो तो adjudicating authority notice serve करे तो भी मुझे देना था. So when adjudicating authority served a notice, if I accept my liability with an adjudicating authority, then also I'm supposed to pay tax, then also I'm supposed to pay interest. But at least when I say I'm not accepting in front of adjudicating authority, I rather have an option directly to approach an alternative channel. This is what we were discussing in the first slide, that it is an alternative channel. So rather than accepting your liability in front of adjudicating authority, you should straight away approach Settlement Commission. That Settlement Commission will do what? So okay, obviously is going to take tax. Is going to even charge interest. I mean, tax and interest is basic thing and nobody can waive it. So tax you are supposed to pay, interest you are supposed to pay. The only relevant benefit that you have is you have approached the Settlement Commission, being a judicial body, has a power to waive or immune your penalty and prosecution liability. So it's a big benefit to you. So, you know, as I said, I would again repeat that entire point. Whenever when I paid tax of 10 lakh and department was of the opinion that the correct is 50 lakh, whenever they serve a notice to me, I straight away first have to decide whether I am accepting this or I am fighting against this. If I am fighting, there is no question of Settlement Commission. If I am accepting this, then in that case I have two options, whether to accept in front of adjudicating authority who has served a notice to me, or I want to straight away approach Settlement Commission. The best option is to approach Settlement Commission, because none of the adjudicating authority has a power to waive your penalty and prosecution. As compared to that, the judicial body like Settlement Commission can straight away waive your penalty and prosecution liability. So it's a big benefit to assessee. So always keep this in mind, that you can apply to Settlement Commission when your case is with adjudicating authority. And case with adjudicating authority is pending, what do we interpret by that also? There was one, I think one case is there, I don't remember the name of the company at this stage exactly, but I think it was something like Qualimex Engineering or something. What was an issue? The issue is till what minute you believe that the case is pending with adjudicating authority. Like I'll tell you, what happened is, let's say on 1st June of a year, any year, I get a notice from adjudicating authority. The moment I say on 1st June I got a notice from an adjudicating authority, I can simply say that now my case is pending with adjudicating authority, and since my case is with adjudicating authority, I can straight away approach Settlement Commission. So from 1st June my proceeding has started. Now let us say when my proceeding has started, it is very clear that I have an option to fight. Now obviously at any point of time I can go to Settlement Commission or I can fight with the adjudicating authority. Let us say on initial phase I decide to fight with the adjudicating authority. So obviously a lot of fact finding will be done by myself, a lot of fact finding will be done by the department officer, and the proceeding is continuing. On 1st October of that year, the adjudicating authority passes an order. Now that order that they are passing is on 1st October. The same order is getting dispatched from the department on 5th October and is received by me on 10th October. I am again saying all the dates. 1st June is a date on which the notice got served. 1st October is a date on which the order was passed. 5th October was a date on which the order was dispatched from department. And 10th October is a date on which I have received that order. So if I say on by or before, see 1st June was a notice day, on 1st October is a date on which the order has been passed. So in between 1st June and 1st October, if I say, can I approach Settlement Commission? Yes, I can simply approach, because my case is with adjudicating authority and nobody can deny me. If someone would ask, can I approach settlement commission after 10th October when the order is also received by me? So obviously answer is no, because I cannot say the case is with adjudicating authority, rather the authority has passed an order and even I have received a copy of the order. The question matter was not with regard to prior to 1st October period or after 10th October period. The question matter was with regard to 1st October to 10th October. So 1st October is a date on which the order is passed, and 10th October is a date on which the order is received by assessee, and also 5th October is a date on which the order was dispatched from the department. So what about both the bifurcations? Can I approach settlement commission between 1st to 5th October? And can I approach settlement commission between 6th to 10th October? Because 1st to 5th October is a period on which the order has been passed but has not been dispatched. 6th to 10th October is a period in which order was dispatched but was not received by the assessee like me. So in both these cases, this Colimex engineering gives a clear point. It says very clearly that in between 1st to 5th October, you can always approach settlement commission. Reason is, though department has passed an order, but yet the order has not been dispatched. And since the order has not been dispatched, from the perspective of assessee, it is still pending at the departmental level. So case is still with an adjudicating authority. It is their internal issue that whether order has been passed or has not been passed, or maybe passed but yet not dispatched. That is not my lookout. Till the dispatched order, I am being very clear that the case is with an adjudicating authority. And since the case is with an adjudicating authority, I can always approach settlement commission. But when I say on 6th October, the departmental authority dispatched the order, 5th October, when the departmental authority dispatched the order. So from 6th, yes, I can say case is not with an adjudicating authority. Koi bole, sir, but I have not received an order. That's okay. That's your lookout. You have not received it. But you can't say that the case is with an adjudicating authority, because technically it is not. They have already released the order. So in between 6th to 10th October, if you say whether I can approach settlement commission, I would say bluntly no. Because the case is still with an adjudicating authority, so your option is open. The same thing is mentioned over here. Till the order is dispatched by adjudicating authority, we can always consider that as case with an adjudicating authority, and hence you can approach the settlement commission. Now let us move ahead with this. This is just an application point that we have talked about us. Now whenever I say I apply to settlement commission, I need to give a disclosure. See, when I talk about disclosure, why a disclosure is required? So let us just understand that. A departmental authority has served a notice to me saying that the tax was not correctly assessed in your case. Let us say in my case the tax was paid as 10 lakh rupees, and according to them this is not a correct assessment. So probably they will serve a notice saying that you have done an undervaluation, or they will serve a notice saying that in your case classification was done in a wrong manner, or you have claimed wrong exemption or whatever. So they will serve the notice accordingly. Now when I say I have received a notice, I use the word that case is with an adjudicating authority. So I can approach settlement commission. When I approach settlement commission, I am asking for settlement. When I ask for settlement, I need to first give my stand. So when I say I need to give my stand is, I need to give a disclosure, whereby I will disclose very clearly that okay, I have originally assessed my tax as 10 lakh rupees, but that was not a correct assessment. The correct assessment is something else. What is that else is supposed to be disclosed over here. So I need to inform, I need to disclose very clearly that what is my correct assessment, and that disclosure will be the base based on which the entire settlement will be done. So technically you have to disclose from your side that what is your correct amount, and the amount that you disclose will ultimately become the criteria for the settlement of any particular proceedings. So let us talk about the disclosure. What are the things that I need to disclose over here? The first point is you need to give a true and full disclosure. It is very clearly mentioned, a true disclosure and a full disclosure. So nothing should be hidden after this. At least you may have done 100 violations, but जिसके लिए नोटिस आया है ना, उसके लिए कुछ पेंडिंग नहीं होना चाहिए. बाकी के मैटर का छोड़ो, तुमने क्या गलत किया, वी आर नॉट डिस्कसिंग दैट पॉइंट. बट जिसके लिए नोटिस आया जिस पॉइंट पे, सो फॉर एग्जांपल मैं जिस प्रोडक्ट में डील कर रहा था, मैंने उसमें क्लासिफिकेशन में कुछ गलत किया हो, सो उसके लिए नोटिस आया है. सो एटलीस्ट फॉर दैट रिगार्ड आई नीड टू गिव अ फुल डिस्क्लोजर एंड इट शुड बी ट्रू एंड फुल डिस्क्लोजर. उसके अलावा मैंने अंडर वैल्यूएशन किया, वो एक अलग मैटर, आई एम नॉट सपोज टू कमेंट ऑन दैट पार्ट. बट एटलीस्ट विथ रिगार्ड टू द पॉइंट विच इज मेंशन इन नोटिस and according to that notice, if I am applying to commission, I need to give a true and full disclosure from my side. So it's very clearly saying give true and full disclosure of the duty liability which you have not disclosed, and obviously in relation to the notice that has been served, not about everything. Now when I say you give a true and full disclosure, it very clearly says that you also need to give the manner in which you have done that. So for example, what was your modus operandi? How did you do that? या भाई मैंने क्लासिफिकेशन में ये कोट करके गलत किया, या वैल्यूएशन में ये कोट करके गलत किया. व्हाट वाज योर modus operandi? We also need to talk about the additional duty liability that we are accepting. There are criteria which are very clear, which says that when you approach settlement commission, so obviously initially you might have paid some tax, and against that you got the notice. So against that notice, when you approach settlement commission, you have to accept the additional duty liability. And when you accept the additional duty liability, the amount that you have accepted shall also be mentioned as a part of the disclosure. So basically you give true and full disclosure. Second thing is you tell them the manner in which you have done that wrong thing. Third thing is you mention the additional duty liability that you are accepting, and that is where you are asking for settlement, that I have done fraud of so and so amount. So you tell them the amount, that I have done fraud of so and so amount and I hereby accept that liability. So that is additional duty liability amount that you have to inform. And more important, it says that you also need to give the particulars of the goods. So basically when you did a fraud with regard to certain goods, and based on which you have done an evasion, so you need to give the particular of the goods. It says particular of goods in respect of which you admit your liability. So you need to mention that also. And the last thing is it says all other particulars as may be prescribed. So technically these are the things which are to be considered when we think of disclosure. Number one is you have to give true and full disclosure. Number two is the manner in which you have derived it. Number three is the additional duty that you are accepting. Number four, you give the particular of goods. And number five, such other particulars as may be prescribed. So these are the disclosures which you are supposed to give when you apply to the authority called Settlement Commission. So when I say you have to apply to Settlement Commission, second, you need to give a disclosure. The third thing which is more important, and that is where you need to follow certain conditions when you apply to Settlement Commission. What are those conditions? The conditions mein jo first hai, that is you need to file all the document in relation to goods. So I mean like when I say what you need to follow is all the documents in relation to goods for which you are applying to Settlement Commission should have been filed. So there is a clause in law which says you can't apply to Settlement Commission in relation to a clandestine transaction. Clandestine is something we call as secret or something we call as hidden. So you can't approach Settlement Commission with regard to secret or hidden transaction. You can approach Settlement Commission only if it is on paper. If it is secret, if it is hidden, the application to Settlement Commission is not feasible. So technically, अगर मैं कोई goods import किया था, उसके लिए मैं Settlement Commission को approach कर रहा हूँ, तो whether I filed bill of entry for that? Same way, अगर मैं कोई goods export किया था, जिसके लिए मैं Settlement Commission को approach कर रहा हूँ, whether I filed shipping bill or bill of export for that? अगर मान लो कि एज अ बैगेज में कोई गुड्स लेके आया था अपने साथ या लेके जा रहा हूँ, तो हैव आई फाइल्ड अ डिक्लेरेशन फॉर दैट? अगर बाय पोस्ट आया था या बाय कुरियर आया था, क्या मैंने उसके लिए डिक्लेरेशन दिया है पोस्टल डिपार्टमेंट को या टू कस्टम डिपार्टमेंट? सो बेसिकली वेदर all the necessary documents in relation to the goods have been filed, and then in relation to those goods you are applying to settlement commission. If you are dealing in some goods which has been completely not on paper, no document has been filed, rather someone tried and smuggled it, and on any given day he has been caught, and now if he thinks to apply to settlement commission, that's not possible. Settlement is possible only in relation to such goods for which necessary documents has been filed. So yes, you have done something wrong, that is always there, but you may have done in terms of valuation, you may have done in terms of classification, but at least you have submitted documents. So since the documents have been submitted, okay, we can think of settlement in that regard. So number one condition is the documents must have been filed in relation to those goods for which you are applying for settlement. So that is condition number one. When I say condition number two, whatever is an additional amount of duty that you are accepting, you have already disclosed, we have discussed in last slide that you have to disclose additional duty liability for which you are applying for settlement. So the amount that you have disclosed has to be paid, and has to be paid along with interest. Now what is the logic of this? See friends, when I say I paid an initial 10 lakh rupees tax, and I got a notice from an adjudicating authority saying that this is not a correct assessment. So against that notice, I approached settlement commission. Now when I approach settlement commission, I have given a true and full disclosure in which I am accepting my duty liability, additional duty. So original 10 lakh to tha hi, but additional duty liability that I am accepting is, let's say X amount, let's say 20 lakh rupees. So when I accept 20 lakh rupees, so law is very clear that when you accept 20 lakh rupees, you need to consider two things. Number one is your additional duty liability that you are accepting is at least 3 lakh rupees. The additional duty liability that you are accepting and you are applying to settlement commission, then this duty liability shall exceed 3 lakh rupees. If it is less than 3 lakh rupees, I am sorry, settlement commission will not consider it. Your first requirement is this. I will again say this, that additional duty liability for which you are applying to settlement commission shall exceed 3 lakh rupees if it is less than 3 lakh, and it is duty which is 3 lakh. So for example, in my case the duty liability was 2,90,000. I am accepting additional duty liability as 2,90,000 and 20,000 is interest payable on that, so it is total 3,10,000. No, I am sorry, your application to settlement commission is not valid. It has to be additional duty liability as 3 lakh. And very, very important, when I say additional duty liability of 3 lakh, it has to be per case also. कोई बोले why per case? I'll tell you. Let's say मैं multiple goods में deal कर रहा हूँ, एक गुड्स में मैंने क्लासिफिकेशन में फ्रॉड किया हुआ है, दूसरे टाइप के गुड्स में मैंने वैल्यूएशन में फ्रॉड किया हुआ है. सो ऑब्वियसली मुझे डिपार्टमेंट की तरफ से नोटिस आते हैं. एक गुड्स के लिए क्लासिफिकेशन के लिए नोटिस आता है, दूसरे गुड्स के लिए वैल्यूएशन के लिए नोटिस आता है. अब मैं अगर सेटलमेंट के लिए अप्लाई कर रहा हूं तो क्लासिफिकेशन इश्यू शैल बी टेकन सेपरेटली एंड वैल्यूएशन इश्यू शैल बी टेकन सेपरेटली, एंड इन ईच ऑफ दोज केसेस इट हैज टू बी एडिशनल ड्यूटी लायबिलिटी टू बी एक्सेप्टेड एज 3 लाख रुपीज इफ इट इज लेस देन 3 लाख. कोई बोले सर एक में 2 लाख एक्सेप्ट कर रहा हूं, दूसरे में 1.5 लाख एक्सेप्ट कर रहा हूं, कैन सेटलमेंट कमीशन कंसिडर माई एप्लीकेशन? आई एम सॉरी, नो, इट हैज टू बी the case for which you are applying to settlement commission. In that you have to additionally accept your liability at least of 3 lakh rupees. So that is first criteria. And the second criteria is when you say you are accepting, for example, I originally paid 10 lakh rupees and I got a notice saying that this assessment is not proper. So against that notice I approach settlement commission. The additional liability that accepting is 20. So original 10 था plus additional 20 मैं accept कर रहा हूँ. So with that I am applying to settlement commission. So can I put it bluntly that I myself is accepting 20 lakh rupees extra, and I am asking settlement commission that please help me to settle down my proceeding? And if that is the case, they are saying that you first pay that 20 lakh and then come to us. Without paying 20 lakh, you can't come to us. Law is very clear. If you say that you are accepting 20 lakh additionally, then what is the reason that you are not paying it? If you are saying that my liability is not 10 lakh, it is 30 lakh, so I am accepting 20 lakh extra, then why you are not paying it? You are bound to pay it. You must pay it. Then only the authority will help you to settle your case. Otherwise, see, you need to show your readiness. आप ऑन पेपर बोल देते हो कि हाँ मैं मानता हूँ मेरी लाइबिलिटी 30 लाख है, बट भरते नहीं हो तो why they should help you to settle your case? So whatever additional duty liability that you are accepting, first it has to be at least 3 lakh, and second, whatever liability you are accepting, you need to first pay it. Then only the settlement commission will consider your case. Otherwise, the settlement commission will not at all consider your case. So both the things has to be kept in mind. Additional duty liability of 3 lakh has to be accepted, and the entire amount that you accept has to be first paid. Moving ahead with this, as I said, it has to be paid along with interest. So moving ahead with this, now the fourth condition says that you cannot apply to settlement commission when your case is pending in tribunal. I mean, like, that is very clear, and I think it is more or less correct only. Because one of the first fundamental point is you can apply to settlement commission when your case is with an adjudicating authority. So if I say that earlier your case was pending with adjudicating authority, they served a notice, you were given an opportunity of being heard, you have tried and proved that you have not done anything wrong, and ultimately they passed an order against you, and now your case is pending with tribunal, then technically now there is no sense of applying to settlement commission and ask for any sort of settlement. The reason is very clear. There are two reasons for that. Number one, when your case was with adjudicating authority, that means yet they are supposed to do a lot of fact-finding work. And then they were supposed to pass an order against you. As compared to that, if you straight away accept your liability in front of adjudicating authority only, then it becomes an easy recovery from their side. जबकि अगर मैं ये बोलूँ कि adjudicating authority has already passed an order against me, that means they have done all the fact-finding they have done all the fact-finding work, then the question matter is why they should agree to settle anything. I mean, rather they will continue with the point that they have raised in the demand in form of adjudication order. So they will never agree to settle down anything. So always keep this in mind that you can apply to settlement commission only when your case is with adjudicating authority. You cannot apply when your case is with tribunal. The other reason, this is the first reason, like I said that because they have done all the fact-finding work and they have passed an order, then rather than agreeing for any settlement, they will continue with the amount that they have decided in the order. But the other point is, which is more logical again, that settlement commission and tribunal and in departmental structure or in organizational structure, both are parallel level bodies. Like tribunal is also a judicial body kind of thing, and settlement commission is also a judicial body kind of thing. Almost they are parallel in terms of level. So when both these authorities are parallel in terms of the level, then if my case is pending with tribunal, that means my case is pending with one judicial body. How can I approach the other judicial body? It's a very clear thing. So settlement commission will never agree on that perspective. So point is, when your case is pending in tribunal, you can never approach settlement commission. The doors are always closed. You can approach settlement commission only when your case is with adjudicating authority, not with the tribunal. So that is one of the conditions that we were supposed to follow. One more point is with regard to prohibited goods or the goods in respect of which you are violating Narcotic Drugs and Psychotropic Substance Act. Now let us talk about that. Let's say one person is dealing in prohibited goods and he has been caught, and now adjudicating authority has served a notice to him, then in that perspective you can never approach settlement commission. Now why you can never approach settlement commission? The point is very clear, because the goods in respect of which you are dealing are called prohibited goods, and when you deal with prohibited goods you can never ever approach settlement commission. That is one of the point. Similar manner, when you are importing something like drugs, which is what we consider under Narcotic Drugs and Psychotropic Substance Act, that means you are contravening a provision which is ultimately also invoking Narcotic Drugs and Psychotropic Substance Act, then in again that relation you can never apply to settlement commission. So basically the rule is very clear. If you deal in prohibited goods, or if you deal in goods or in some way you are contravening Narcotic Drugs and Psychotropic Substance Act, then you can never apply to settlement commission. This is one of the basic criteria which has been kept, कि आप कभी भी इन cases में settlement commission को approach नहीं कर सकते. One more restriction is with regard to classification of goods. So you can never apply to settlement commission in respect of any matter which involves the classification of goods. So if it is, if at all it is a matter of classifying anything, then yes, you can never approach settlement commission. So for example, if I deal in a product, I'm not sure whether it would come under X heading or it would come under Y heading. In that respect, I can never approach settlement commission, as it has been very clearly mentioned as no application for cases involving classification of goods. So that is one of the point which is mentioned. Now in relation to all these things, there are a lot of cases involved. Like I'll give you few examples, or rather we'll discuss few of them. One of the first case study is with regard to this point that your case is pending with tribunal and all that. So I mean, like as I was talking about, कि अगर मान लो कि मेरा केस एडजुडिकेटिंग अथॉरिटी के पास है तो आई कैन अप्रोच सेटलमेंट कमीशन, और अगर वो केस एडजुडिकेटिंग अथॉरिटी ने ऑर्डर पास कर दिया है और ट्रिब्यूनल के पास गया है, तो अगर वो ट्रिब्यूनल के पास पेंडिंग है तो आई कैन नॉट अप्रोच सेटलमेंट कमीशन. So what happened in particular case is, when case was with adjudicating authority, assessee has not approached settlement commission. Rather, he waited for the verdict. So adjudicating authority passed the verdict. Against that, in general course, you apply to the appellate authority. So assessee approached appellate authority. Now, when appellate authority was going through all the points which were there in the order of the adjudicating authority, they identify that the case has not been properly adjudicated. So rather than hearing appeal, appellate authority send the case back to adjudicating authority for fresh adjudication. The moment appellate authority send the case back to adjudicating authority for fresh adjudication, we can again say that the case is now pending with adjudicating authority. So if the case is pending with adjudicating authority, can we approach to settlement commission? This is the verdict which I am talking about. So what happened is, initially your case was with adjudicating authority, and obviously you can approach settlement commission considering that. But you have not approached, rather you fought against that. The authority passed an order. When the authority passed an order, in normal course the option that you have is you have to approach the tribunal or commissioner appeal as the case may be. Now in this case, assessee approached the tribunal depending on the level of authority who has passed an order. So when assessee approached tribunal, so tribunal will normally hear your case and will hear your appeal and ultimately will pass a verdict at the end. But if tribunal at any point of time feels that the case is not properly adjudicated, maybe certain evidences were not considered or assessee was not given enough opportunity of being heard or something like that, then in that case the tribunal has exceptional power whereby rather than hearing the appeal can send the case back to adjudicating authority with a specific instruction that you have not done earlier this point, like it can be said that you have not considered X evidence or Y evidence or Z evidence at the time of passing an order. So we are sending a case back to you, you consider X, Y or Z or whatever is an evidence, and accordingly you pass the revised adjudication order. So this can take place. So in this case, same thing happened. Appellate authority sent the case back to adjudicating authority and asked the authority to revise the adjudication. Now when I say it was sent back to adjudicating authority, we can say that the case is again with adjudicating authority. Now can I apply to settlement commission? Now this is the case which we were discussing. So clear verdict was given saying that no, you cannot approach settlement commission in this case. The reason which was laid down was very clear. When I say the reason which was laid down was very clear. When I say cases with adjudicating authority means yet adjudication is not done, yet the fact finding work is not done. In our case, what has happened is already the adjudication was done. And against that the matter went to tribunal. So when tribunal rejected it or rather sent it back to adjudicating authority for fresh adjudication, two things comes in. Number one, it has been already addressed by tribunal, and tribunal and settlement commission both being parallel authority. Once the case goes to tribunal, settlement commission should not entertain that. That's the first reason. Second, tribunal has sent a case back to adjudicating authority for revising adjudication considering X, Y or Z evidences, meaning thereby the case was once adjudicated, and the moment you say that case is once adjudicated, the doors of settlement commission gets closed. Reason is very clear. You can apply to settlement commission when your case is with adjudicating authority, when means that it is yet not adjudicated. In our case, it has been sent for revised adjudication. So in that case, you can't consider as case with adjudicating authority being not adjudicated at all. So in that case, settlement commission ka door always close हो जाएगा. One of the second verdict which I would like to discuss is with regard to classification. I think कोई Australian Foods करके कोई company था, and the case was with regard to excise, but it is relevant in this particular scenario. That is why I am discussing it. That the case was with regard to I think method of valuation. The company was dealing in some sort of biscuits, and they were offering those biscuits in a pack form to consumers, but was not directly offering it, rather it was getting offered to institutional consumers. Now in excise there was a criteria which says that generally when goods are sold in a packet to consumers, it has to be sold as per MRP valuation. So excise duty has to be paid as per MRP valuation. But that point was also having an exception, that if you don't offer goods to end user, rather you offer to industrial or institutional consumers, then MRP method of valuation is not applicable, rather the correct method of valuation will be transaction value. So technically two options are there. One is MRP and another is transaction value. ACCA was following MRP for calculating excise duty, even if it was selling of goods to institutional consumer. And along with that, department was of the opinion that yes, the correct method of valuation is not MRP, it is transaction value. So department served a notice. Now this involves valuation perspective. So can ACCA apply to settlement commission for that? So yes, answer is yes. But now there was one more point as a part of this entire issue, that was with regard to classification perspective. The biscuit was made up of some sort of dough. Now the concern issue was, if I say it's made up of some sort of dough, whether it should come under X category or it should come under Y category. If at all it will come under X category, then its classification will be something different, and if at all it will come under Y category, then its classification will be different. And depending on the classification, the method of valuation also gets decided. So technically there was a method of valuation issue, but it was also directly related to the classification of goods. So the concern issue was that if at all it will come under X classification, the method of valuation can be MRP or transaction value both. But if it comes under Y category of classification, then there cannot be an MRP, there can be a transaction value only. So the first thing was to decide whether it is under X category or under Y category. If at all one say that it is Y, then there is no question, there can be only transaction value. If it is X, then there can be both the methods possible, because X type के product के ऊपर दोनों methods थे, transaction and MRP. So technically, when method of valuation was one point, okay, we can approach the settlement commission. But if the issue is with regard to purely classification of goods, then yes, the application to settlement commission is not addressable, and obviously your application will straight away get rejected. So this is one of the point that we need to consider कि भाई ये सारी conditions है जो आपको always ध्यान में रखनी है when you apply to settlement commission. There are few miscellaneous issues also involved, like when you approach settlement commission, keep this in mind that whatever application that you make once, it cannot be withdrawn. Like this is something which is different from authority of advance ruling. In advance ruling, there is a criteria which says that once you submit an application, at any point of time you can withdraw within 30 days period. But the same thing is not there in case of settlement commission. Once the application is submitted, means submitted. You cannot withdraw it at any point of time in between. The second point is, application shall not, at the time of application you are supposed to pay prescribed fees. That fees is actually 1000 rupees which you are supposed to pay at the time of application. And if your application gets rejected, then that is refundable also. So technically you are supposed to pay prescribed fees, and it can be refunded as and when required. So these are the basic conditions that we are supposed to follow when we apply to settlement commission. So technically we have discussed that you have to apply to settlement commission when your case is with adjudicating authority. What do we understand as case pending with adjudicating authority? We have already discussed. Over and above that, we have talked about the disclosures that we are supposed to give when we apply to settlement commission. When we disclose certain facts and figures, accordingly settlement commission will consider it. More important, these are the conditions that we always need to keep in mind when we apply to settlement commission. That you cannot apply for clandestine or secret transaction. Ultimately document has to be submitted, then only you can apply to settlement commission. The second point was minimum additional liability to be accepted is 3 lakh per case, which I have already explained. Then the additional amount has to be deposited, then only they will consider your matter. Your case should not be with tribunal, pending with tribunal, otherwise settlement commission will not consider it. It should not be any sort of violation with regard to prohibited goods. or it should not be fall under the Narcotic Drugs and Psychotropic Substance Act. Last one which we have talked about is there should not be a matter with regard to classification of goods, and you have to pay prescribed fees, and the last point which we have talked about is your case cannot be withdrawn. Now this is basically application stage. Now when you have applied, so now the authority will take a call whether to accept your application or to reject your application. So let us talk about that point, that is acceptance or rejection. Whenever an application gets submitted, within 7 days served by the Settlement Commission asking the explanation. Now technically this notice is different from the notice which has been served by adjudicating authority. Basically, when adjudicating authority serves notice, then only you say that your case is pending with adjudicating authority, and then you apply to Settlement Commission. But when you apply to Settlement Commission, one more notice will come asking for explanation. A straight notice will be there where it will be asked that explain or cause that why we should accept your application. So when such notice, this kind of notice comes within 7 days. 7 days from the date when you apply. So if you apply today, then within 7 days a notice will come to give the answer. You have to give that explanation, the logic, the reason that why they should accept your case. And the moment you submit your explanation, now they will pass an order. An order will be passed within 14 days, either accepting or rejecting your application. So whether they wish to accept or they will reject, but whatever will be there, it will be done within 14 days. And within 14 days, they will either accept your application or will reject it. Someone who says, sir, what if no answer is given within 14 days? Then technically your application is deemed to be accepted. In two cases, your application gets deemed to be accepted. Number one, when you submitted your application, within 7 days no notice has come, which is this one, which is why we refer to 7 days a notice should. So within 7 days, if no notice will come, then also your application is deemed to be accepted. Or let's say a notice has come, against that you have to give an answer. When you give an answer, so a notice has come today, so now you have to reply it. When you reply, you submit your explanation. Now they have to within 14 days answer that whether they are accepting your case or they are rejecting your case. If that answer is also not come in both the cases, so when I applied, they failed to serve a notice to me, or probably they have served notice and I have given an explanation, now they failed to revert. In both the cases, your application is deemed to be accepted within 14 days. Achha, very important, when I say if they wish to reject it, so they can reject it, there is no doubt, because there are various reasons like let's say the additional duty liability that you accept is less than 3 lakh. Or let's say it's a case with regard to prohibited goods, or the case involves Narcotic Drugs and Psychotropic Substance Act, or it is with regard to classification of goods, or anything like that. So in that case, they do have a right to reject your case. But no rejection shall take place without giving an opportunity of being heard. That is one of the fundamental things. They first need to give you an opportunity of being heard without rejecting your case. So, I mean, like principle of natural justice, that you should hear me at least once before rejecting my viewpoint. So that is one of the point. Acha, koi bole, sir, what if they will accept it? So if they will accept it, then a copy of that will be forwarded. So I mean, like acceptance point will be straight away forwarded to the judicial commissioner or principal commissioner. Why? To get to stay. I'll tell you why. See, what has happened is my case was already pending with adjudicating authority and I straight away approached Settlement Commission. So when I approach Settlement Commission, so Settlement Commission will now hear my point. When I say Settlement Commission will hear my point, so obviously what about the adjudication which was already pending? So what will happen is when Settlement Commission will accept your case, then a copy of that will be straight away forwarded to the adjudicating authority and automatically stay will be granted in adjudication. So now whatever will be decided will not be decided at an adjudication level, rather will be decided at the settlement level. So whenever a case is accepted, a copy of that will be forwarded to the jurisdictional commissioner or jurisdictional principal commissioner, and automatically stay will be granted at that point of time. And when I say stay will be granted at that point of time, so entire adjudication proceeding will stop and will remain stopped. Ultimately, I mean, will remain stopped at all, because when Settlement Commission will pass an order, that order itself will be binding order, so adjudication will be over at that point of time. But if at all there is a case in future where a Settlement Commission rejects the case,